Hi, thank you very much for inviting Fair Trials to speak, and I appreciate this is the graveyard shift, and so I'll try and not to repeat things that have already been said and keep it as interesting as possible. If you haven't heard of Fair Trials, we're a criminal justice watchdog with offices in Brussels, London, and Washington, and a presence in Latin America. So on the topic of artificial intelligence, our interest is particularly in relation to criminal justice. In the context of the definition, I know there's been quite a lot of that already today, and as lawyers you'll be very interested in definitions and meanings, and there's no true accepted definition of artificial intelligence, particularly how it's used in practice, and the term has been used to encapsulate the most basic of automated computer-based analytical systems. I think the conception in the guide that's been produced is as a general objective of such tools to replicate human intelligence is a useful way of looking at it, so you don't get too tangled up in conceptions of technology. And there are many potential uses. Again, we've heard of many of them, of AI and automated decision-making systems in criminal justice, some of which are considered in the guide. Obviously, those are kind of focusing particularly on activities, or those that are relevant to lawyers' day-to-day activities, drafting support tools, document analysis, case law retrieval and analysis. I would say that those are they can generally be at the safer end of the scale in terms of how some of these technologies can and are being used by criminal justice authorities, law enforcement, and other authorities. But the developers and indeed the users yourselves of these systems have to be aware that the kind of large language models that analyze case law, judicial reasoning, pronouncements, can very easily perpetuate the kinds of stereotypes and biases that are found in those original texts and reasonings. So other uses of AI that we're particularly interested in at Fair Trials include data analysis and prediction tools, surveillance and evidential tools like facial recognition, digital device extraction from mobile devices, something that's becoming an increasingly fundamental element of law enforcement, and also the analysis of the kind of huge amounts of data that is being taken by law enforcement and criminal justice authorities. You know, that kind of disproportionate and invasive surveillance and data capture in many of those tools has an incredibly serious impact on people, and engages and in many cases infringes their rights. Authorities are seeing these new technological advancements as an opportunity to both allow themselves and also to justify the collection and further seizure of huge amounts of data and analyzing it using these advanced systems. So, you know, there are a number of concerns. We've heard, quite a few of them in terms of privacy around prediction systems, and it's actually on those prediction systems I'd like to focus because that's a class of systems that we're at Fair Trials are particularly concerned about. And I think it's something that all lawyers, particularly those in criminal justice, should be aware of as their outcomes exert further influence on policing and law enforcement decisions and criminal justice decisions as well. So these are the kinds of systems that are used to profile people, to predict their future actions, or assess their risk of certain future actions, sometimes linked to criminality, but often just linked to undesirable social behavior. These predictions, profiles, and risk assessments can influence, inform, or result in policing and criminal justice outcomes, including surveillance, monitoring, stop and search, fines, questioning, and that's just pre-arrest, and then arrest itself, bail and pretrial detention decisions, even prosecution decisions, as well as influencing sentencing and probation. And they can also, and they are being used in the context of non-criminal justice punishments, such as the denial of welfare, the denial of other access to other essential services, and sometimes even in kind of other areas like child welfare and the removal of children from their families. So we've been conducting research into this, and we published a report if you are interested in reading more about this, called Automating Injustice. And what we found was that the use of predictive profiling of risk assessment systems being used in Europe, not just that could be theoretically used in future, not that just being used in the US, but that are being used in Europe and the EU right now. Predictive systems which fuel and legitimize racial and ethnic profiling and discrimination. which are normalizing preemptive law enforcement action and criminal justice action, and which, as a result, are infringing fundamental rights, including the right to a fair trial, the right to liberty, the right to a private and family life, and data protection rights. And more than just their infringement on rights, they're having a very real and tangible impact on people's lives. These systems are often being introduced with little or no safeguards, no consideration of their impact on the individuals and groups targeted and subject to them, and with negligible consideration for human rights and the wider societal impact. They are, as we've put it, effectively automating injustice that we know that exists in society, but it's being automated. I will just very briefly consider an example in case some of you don't know about this. There's a system that's being used in Amsterdam by police and the local authority, which is called the Top 600. It's an automated system which is profiling children as young as 16, and there's another similar system that profiles children as young as 12. What it's attempting to do is assess their risk of committing crime in future. And in order to do that, it includes not just criminal justice data, such as whether they've had contact with the police. It doesn't necessarily require that they've been arrested, merely that they've had contact, whether it's an ID stop or a check. One of these systems also uses education data, so whether the child missed days of school, whether they moved school, completely unrelated criminal justice data. It also uses financial information, including whether people or those associated with them have been involved with a bankruptcy judge. So there's very kind of clear, unacceptable information being used, which is very likely to lead to bias and discriminatory results. And at least a third, and as many as half or more of the young men who've been profiled by that system are young men of Dutch Moroccan heritage. So there's a very clear discriminatory output in the decisions made by that system. And that leads on to the major issues that we and others have tried to talk about in the context of these systems. The first one of those is discrimination, that these types of systems, but also to some extent the kinds of language models that you see in the use of automated text analysis and processing tools that are trying to reproduce judicial reasoning. They often reproduce and reinforce discrimination, and that's on grounds including but not limited to race, ethnicity, nationality, socioeconomic status, gender, and as well as people's disabilities. As you know, and as we've heard, this is all due to the data that these systems are being trained and operated on. In the context of criminal justice, again, as you'll know, law enforcement, police data, prosecutorial data, judicial reasoning and decisions, they do not necessarily represent an accurate record of criminality, but merely a record of those institutions and how they go about their daily business, who they police, who they target, the crimes, the locations, the groups that are policed, prosecuted, and criminalized within society, rather than the actual necessary occurrence of crime. That data is reflective of systemic, institutional, and societal biases, and I'm sure many of you heard this before, but it bears repeating given the way that many actors in the system continue to push and develop these tools. But that data, and therefore the systems developed upon them, are often reflective of systemic and institutional and societal biases, which, for example, in Europe result in black people, Roma, and other minoritized ethnic people being over-policed and disproportionately detained and imprisoned in Europe. Even, unfortunately, seemingly legitimate data, so non-criminal justice data, which is often used in these systems, which does not reflect or directly represent ethnicity or nationality or any of these other protected characteristics, it can often be a proxy for those factors. For example, the use of home addresses or area codes, particularly in areas in Europe where there's quite high pronounced ethnic segregation. It makes it highly probable in practice that those systems will inadvertently establish a link between those areas and people from that backgrounds. In the context even of language models, drafting tools that you've heard about, it is good to be aware that these tools themselves can often assign high probabilities to this kind of biased data. AI tools that are kind of looking for these hidden patterns in language They capture everyday uses of language that are often biased or racist or sexist or ableist. As a crude example, Fair Trials has conducted a lot of research into discrimination against Roma in criminal justice systems across Europe, and Roma are often discriminated against by judges due to racist perceptions about their lifestyles, resulting in increased criminalization, increased pretrial detention, and increased conviction. And as I say, it is a crude example, but to analyze, if you use an AI tool to analyze the language that judges and judicial reasoning conducts in some cases, in often many cases actually, in relation to Roma defendants, that kind of bias is captured by those language models. A second and main point is around accountability and transparency. And again, I'd just like to echo what has been said on this before. It's a very key problem with the use of systems and many types of technologies in this field, is that due to both deliberate commercial efforts to conceal the inner workings of AI systems and for legal and profit-driven reasons, but also the nature of the technology itself is often unreadable or unable to be used in the kind of format, particularly in justice or criminal justice decisions. And of course, because these systems can and are being used in a way that is significantly influencing criminal justice decisions, they have to be open to public scrutiny in the same way that judicial reasoning and judicial decision-making is and should be. And there's also issues of kind of the uncritical adoption of AI decisions, as has also been touched upon, where it effectively gets used as evidence. A related problem to that accountability issue is the lack of proper rights of redress. There's no proper accountability often. Who's using these systems? What are they being used for? What information is being used to make those decisions? There are often not clear routes to challenge them. The data protection kind of framework, in our view and in many other people's view, is not sufficient to allow people to seek proper redress in this area. A major problem is that if you don't know that a system has even been used, as a lawyer or as a defendant, you're just in no position to challenge it. A final major point is around the right to a fair trial and the presumption of innocence. Particularly in the context of these kind of predictive profiling and risk assessment tools that are seeking to profile someone's future behavior before they've actually committed that action or carried out that action, that completely undermines the presumption of innocence, because this kind of prediction or profile is trying to assess a future action, something which they are entitled to the presumption of innocence for. As an interesting thought, in many jurisdictions, it's prohibited to profile judges and their reasoning in this context, and I'd ask why it's fair to profile defendants and why they shouldn't be entitled to similar rights. It's not exactly the same correlation, but it's worth bearing in mind. So these tools can also, of course, have an impact on other rights, the right to liberty, in as much that they use huge amounts of personal sensitive information about us and about defendants. They engage people's private and family lives, as well as other data protection rights. So finally, on solutions, it's very good that the European Union is taking action on the use of these systems, and there are a number of kind of positive provisions in the AI Act. We are, however, very worried about these types of predictive profiling and risk assessment systems, among other systems. And our position very much reflects and supports what the CCBE are coming out with, as Ileana stated. We believe that there should be a prohibition, a narrow prohibition, on the use of predictive profiling and risk assessment systems which are seeking to predict people's future actions or future criminality in the context of criminal justice action, whether that's pre-arrest, for bail and pre-trial detention decisions, sentencing decisions, or probation. That's something that's supported not just by the CCBE, the European Criminal Bar Association, but a number of other, more than 40 other rights and race equality and lawyers organizations across Europe. We are in the process of advocating for that, and there are a number of, we're getting some quite good support from the European Parliament. We are also, something that you might be interested in, we're in the process of coordinating a joint letter from experts, academics and lawyers about the use of these systems to be sent to the European Parliament. So if this is a field that interests you and it's something you'd like to have a say in, please get in contact with me at Fair Trials, because it's something that we're hoping to send in the next few weeks, and we appreciate as much support on this issue if you're interested in it as possible. The only other things I'd say is that in the context of other systems, because this is, as I say, just one or some uses of AI, and there are many, many uses, some of which we haven't even conceived of yet, but we believe that there needs to be full transparency, including a public register of systems that are used, who's using them, what they're being used for, the data that's being used. As the guide says, as lawyers, you should push for that kind of that kind of transparency and accountability, and I hope that you do. We believe there should be this right to notification, which kind of is kind of fundamental. If you don't know that a system is being used or how it's being used, you have no route or possibility to challenge it. And of course, there also needs to be a clear route to challenge that decision once you know about it. So that's our position on it. We welcome further discussions from you, from people interested in this area, and thanks very much for having us.